Ladies and gentlemen, dear colleagues, first of all, I would like to thank organizer and this time my dear colleague Professor Timea Barzo and my dear colleague Suzana Kraljic for organization here in Maribor. And I must say that I spent a lot of time here in Maribor working, a lot of times at the Symposium Medicine and Law. And I'm very glad to be here again. I would like to say that this project that we have for the past year is some kind of a continuation of my work at the University of Novi Sad, Faculty of Law, as we had a project lasted for 11 years, Biomedicine and Law. I was the director of this project, and it was financed by Ministry of Education and Science. So this project is just a continuation of my work in this field. And it's ongoing research, as we all know. I will start with this Latin proverb and Latin law sentence, infans conceptus from pro jam natu habetur, quotius de commodo eius agiter. This is about protecting the interest of a conceived but unborn child. But the use of artificial reproductive technologies for the conception of a child leads to the situation that it is necessary to review this and other traditional postulates of family law. In the context of ART, the question arises whether it is possible to consider the protection of the interest of a child who has not even been conceived yet. That is something very new for this century. Should society take into account the interest of the future child, considering the fact that conception occurs through the use of ART, and ART is regulated by law, so it is possible to put some limitation or something else. In the family law literature, the best interest of the future child is considered first in terms of assessing the suitability of the future parents, thus the conditions which future parents should meet and are prescribed by national law. These conditions enable future parents access to ART. And in Serbian legislations, this is these conditions: majority, legal capacity, cohabitation between beneficiaries, that means potential parents, capacity of persons to perform parental rights. This is according to Serbian law on biomedically assisted fertilization. Another interest or the right maybe of the child conceived by ART, I think it's very important to discuss the right and interest of the child to have two parents. The question can be raised as to whether there is an interest or maybe a right of the child to have two parents. This question is raised in the context of the situation of a woman without a partner, single woman, using ART, and also in the situation on posthumous fertilization, but only de facto, because de jure in posthumous fertilization, the child has a father, but he is deceased. So it's just de jure, and de facto child doesn't have a father. So why I think that this interest, and not me, but other scientists, what is the interest of the child to have two parents? First of all, there is the child's psychological interest to have two parents. This is in the sense of identification with the parents, with two different persons. After that, there is developmental interest in the sense of being brought up by two different people. And there is also material interest. This is the interest to have maintenance, to get maintenance from parents, and right to inheritance. There is a solution, comparatively speaking, which is a solution to think about interest of the child to have two parents, but in a different way. This is the solution existing in United Kingdom, and it calls supportive parenting. What it is supporting parenting? So this requirement is regulated by a United Kingdom guideline and states where the child will have no legal father, the center should assess the prospective mother's ability to meet the child's or children's needs and the ability of other person within the family or social circle willing to share responsibility for those needs together with the mother. Well, supportive parenting seems a good solution in Serbian society because we can say that in Serbian society, social relations and family relations are very well developed, very important for individuals. So I think it won't be very hard to find a person who will help mother, if she is single, to bring up the child. So my suggestion would be the lege lata, to introduce the supportive parenting, the lege ferenda, to introduce the supportive parenting solution in Serbian law, and to have this interest satisfied. Another solution I found in German law. In German law, assisted reproduction is reserved for married couples. A woman without a spouse can be allowed access to ART techniques only if the doctor is satisfied that the woman has a permanent male partner who is willing to acknowledge the paternity of the child to be born. But in practice, however, practice differs significantly for the current regulation. So there are clinics that allow access to ART to women who do not have a partner, and the usual practice is that medical assistance is conditional on the woman specifying a person who agrees to pay child maintenance. Very often, it is the woman's parents. So this is the practice which differs from real law in Germany, having in mind material interests at the first place. However, in some countries there is a strong opinion that the child interest in having two parents through the application of ART does exist, and as a consequence, a woman without a partner is not allowed access to ART in some countries, for instance, France, Austria. Another right or interest of the child born as a consequence of ART is the child's right to know his or her biological origin. It could be said that there are three basic interests of an individual to know his genetic origin. What are these interests? There is psychological interest, which is very important because of the need for identity. Then this is a medical interest, which is desire to know medical history. How is there some genetical disease or something in this family? Interest connecting to the bloodline, which is material rather than psychological, and this is inheritance or maintenance. United Nations Convention of the Right of the Child, in Article 7, says, the child shall be registered immediately after birth and shall have the right from birth to a name, the right to acquire a nationality, and as far as possible, the right to know and be cared for by his or her parents. So there is some kind of obligation for national laws. So, in 1984, so it's more than 40 years from today, in Sweden, the Act on Insemination in Sweden introduced the right of a child whose conception was result of artificial insemination by donor sperm to know the identity of a donor. 40 years ago, if you can imagine. So there are now a number of countries in Europe that allow the child to get the information, identity information of the donor. And in these countries, these laws, it is prescribed when it is possible to get this information. So in Sweden, child has to have necessary level of maturity. In Austria, has to be 14 years of age. In Netherlands, 16 years of age. In Switzerland, 18 years without any condition, or in other age if material interest is proved. The data on donor should be kept 80 years. In Netherlands and in Switzerland, we have this provision. But in some countries still, there is no right of the child to know his biological origin. For instance, in France, Russia, and Serbia today. And I will just mention, I don't know how time goes. Do I have enough time? Okay. Okay, oh, thank you. So there is one specific interest of the child, and this is the interest that we called pre-implantation genetic diagnosis with savior siblings. These are specific cases of using medical assisted reproduction that pose moral and ethical concern, which result in diametrically opposite views. So, this is the use of pre-implantation genetic diagnosis to choose embryos that have been found to be the perfect donors of the child who is already born and who is sick. So this is very morally concerned. Is it should be allowed or not? And this is a very big question. Two cases concerning savior siblings that I can find are Hashimi case and Whitaker case. So we already have some cases in practice. I don't know if I have time to go into these cases, or okay, I will do that if you would like to listen. So in the first case, the child named Zain was born with a blood disorder known as thalassemia major. So it's a sick child. his condition could be cured by stem cells of a compatible donor. The probability of getting a child that would be an adequate donor was 1 to 4, and Mrs. Hashimi decided to give birth to another child, given that existing siblings could not be the donors to little Zane. However, as pregnancy revealed that the baby is also the carrier of the disease, Mrs. Hashimi decided to end this pregnancy. As a result of the next pregnancy, a healthy boy was born, but not a compatible donor. Subsequently, Mr. and Mrs. Hashimi managed to obtain embryos through the IVF procedure, but only 2 embryos were found not to be carriers of the disease and could be donor to Zane. However, even though 1 embryo was implanted, the pregnancy was not successful. So nothing happened as a result of these difficult procedures. In the second case, a boy named Charlie Whittaker suffered from a rare form of anemia, which was a result of a genetic mutation, and that was the decisive fact for the court. Namely, their request was rejected by the Human Fertilization and the Embryology Agency in the United Kingdom on the basis that, unlike the Hashimi case, Child's disease was not hereditary, but was caused by a spontaneous genetic mutation. This means that the chance of Mrs. and Mrs. Whittaker getting another child with the same form of anemia are negligible. This, however, raises a question whether it is morally justified to conceive and give birth to a child for that purpose only. Of course, those parents claim that they will love the other child the same way as the previous one, and that specific conditions under which the child will be born will have no effect on child's future life. Very often, parents and judges are prone to view this issue as a conflict between a sick child and an embryo, and to conclude that academic principles are not enough to forbid the only possible solution for treatment. In addition, they see that the embryo has enormously advantages by the invasion, while it would never have been selected and it would never have been born if the procedure did not happen. But indeed, you have got to have a very powerful reason to resist the means by which a child's life can be saved. So these are 2 cases and provoke very many questions about these procedures. In Serbia, it is explicitly stated that this pre-implantation genetic diagnosis procedure is permitted, but only when there is a risk of passing on inherited conditions, diagnosis of chromosomal and genetic disease, or if it is necessary due to a repeated unsuccessful IRT procedure. This is according to the law on biomedically assisted fertilization. And as a conclusion, I would like to stress that in the doctrine of civil law, one speaks of balancing values and interests, so that the legislator in a number of situations limit the rights of enjoyment of and disposal with personal values, estimating that the realization of some other values and interests is more important than the realization of the particular personal value. The balancing different interests has an exceptional importance when the right of the child in connection with ART is concerned. Right to ART is considered as a reproductive right, which is one of the human rights. On the other hand, protection of the right or interest of a future child in some situations needs limitation of the reproductive rights. The child's rights to have 2 parents or to be raised by 2 parents should be considered in the context of the situation, as we say, of woman without a partner, jus character, and in posthumous fertilization. The right of the child to know biological origin is in connection with ART and is limited or completely denied. The question is whether these limitations are justified, whether the rights of another person are stronger and more important than the right of a person to know one's biological origins. These rights are the right to privacy, right to be anonymous donor of the biological parent, family stability of the family. Having in mind interest of the child to know one's biological origin, there are solutions accepted in a number of European countries which allow, as we saw, the child access to identity information of the donor of reproductive material. And at the end, I will say that at the beginning of using ART is considered mostly as a reproductive right, which is one of the human rights, of course. But contemporary aspect of using artificial reproductive technologies should be to consider the rights and interests of a future child to have, and these rights to have same importance as reproductive rights, or maybe to be more important, as I think. Thank you for your attention.